I'm Michael Myers from the New York Attorney General's Office. My perspective is slightly different from those of other members of the panel. As an environmental lawyer, I've worked for the past 15 years at the Attorney General's Office counseling state regulators on legal issues related to air pollution and climate change, and also litigating those issues in the courts. It's particularly appropriate the committee should seek to hear state perspectives because under the provision of the Clean Air Act that EPA is using for the Clean Power Plan, Section 111D, states are in the driver's seat. But for us to succeed in this critically important area, each state has to be willing to take the wheel. From the perspective of a state, New York, that has already taken action to cut power plant greenhouse gas emissions, I have good news for other states. You can significantly reduce these emissions from the power sector and do so in a way that helps grow your economy. New York and other states in the Regional Greenhouse Gas Initiative have reduced greenhouse gases from the electricity sector in our region by 40% from 2005 levels. And reinvesting the proceeds from the auction of pollution allowances in renewable and energy efficiency projects has kept down electricity costs in our region. EPA's Clean Power Plan would build off the work that the RGGI states and others like California have done in this area. The plan would cut greenhouse gases from power plants by about 730 million metric tons, equivalent to the annual emissions of powering half the homes in America. The shift to cleaner generation would also result in substantial public health benefits, including 150,000 fewer asthma attacks by 2030. But back to the point I started with. For this plan to work, states have to be willing to step up. Some are discouraging states from doing so on the grounds that the Clean Power Plan is unlawful. My written testimony highlights why such arguments are meritless. First, action under Section 111D to address greenhouse gases from fossil-fueled power plants is required under the Clean Air Act. The law requires EPA to ensure that states achieve emission reductions from power plants necessary to protect human health and welfare from the harms of carbon pollution. Second, EPA's regulation of hazardous air pollutants from existing power plants under one provision of the Clean Air Act does not preclude the use of Section 111D to require those plants to cut their greenhouse gas emissions. The implication of that claim is that EPA had a choice. It could either use the Act's hazardous air pollution program to cut power plant mercury emissions that poison the fish we eat, or it could combat climate change by using the provision the Supreme Court said speaks directly to power plant carbon emissions. Not only does this interpretation defy common sense, it's wrong as a matter of law. Third, it is clear that EPA has the authority to set substantive emission limitations for states to meet. In the absence of such a benchmark, state plans could vary widely in terms of their stringency and effectiveness. States have a lot of flexibility, however, on how to achieve their emission targets in a way that best suits their respective circumstances. Fourth, it's also clear that EPA has the authority to interpret the best system of emission reduction to reflect the various ways in which states and utilities have reduced greenhouse gas emissions from the electricity sector. EPA's building blocks approach appropriately recognizes successful strategies such as cap and invest programs, renewable portfolio standards, and energy efficiency that states and utilities have already shown can significantly reduce carbon emissions and do so cost effectively. In conclusion, here's what I'd urge state regulators to consider. The world scientists are telling us that we need to act now if we're to have a chance of avoiding catastrophic harms from climate change. Our faith leaders are telling us we have a moral imperative to act. The law, the Clean Air Act, requires us to act, and EPA's plan for cutting greenhouse gases from existing power plants is on sound legal ground. Both EPA and your fellow states are open to working with you on how best to cut emissions in your state. The time is now for state leadership, so take the wheel. thank you for the opportunity to testify, and I look forward to answering the committee's questions.
Well, thank you, Mr.